he died in between, like right in between me and Jose. Like as we're both right there next to him. And I remember screaming, "I'm sorry," and just over and over again.
To whom were you sorry?
You know, the homeowner. Just I was sorry. Period. You know, it was a bad situation. I was sorry for it all.
18-year-old Blake Lehman. He is talking about a burglary gone wrong in Elkhart, Indiana. So here is how it played out. 4 teenagers. They were convicted of murder because the 5th guy was killed by the armed homeowner. They thought the house was empty when they decided to break in. None of them were armed. Each, though, got a 50-year sentence, and state law there says that someone can be charged with murder if someone else is killed while a crime is being committed. Now, the state Supreme Court is now hearing the case, and we could be getting a decision any day, and it's been expected that if, in fact, the conviction is upheld, this could go all the way to the Supreme Court. All right, Amy, you brought this to our attention. So just so everybody's clear, because the facts are a little confusing. 4 kids break into what they thought was an empty home. None of them got a gun on them.
It's actually 5 of them break in.
5, excuse me.
Yes.
They break into a home, all of them unarmed. They think the home's empty. Homeowner comes down, sees people breaking in, shoots one of the 5, killing the 5. The other 4 are responsible criminally for the murder, even though they did not lift a finger to the guy, but because they were all part of the commission of the crime. Do
Correct.
I have it right?
Yes, and the reason for the felony murder rule is it's supposed to apply to this classic case of if you have a bunch of people going in to rob a bank, and you have the getaway driver, and you have the unarmed people, but then you have the guy with the gun, and he shoots the teller. Well, everybody should be responsible because they could foresee the shooting of the teller. But in this circumstance, if these teenagers could foresee that the homeowner would wake up and kill one of their friends and they'd be held responsible, or that the homeowner would try to kill them, maybe they would have gone in there armed. They were unarmed. That shows that they couldn't appreciate the consequences or the risks of what would happen. And that's the reason why the FMR is so controversial when it is applied to teenagers. Because, you know, there have been studies that adolescents, their brain development isn't the way that adults are. They can't foresee things in the way that adults can.
But even if we don't go to the distinction of whether they were teenagers or 35-year-olds, it's just, I never knew, Bill, that the law allowed you to be held liable for a murder if you never drew blood on the person.
Well, if this was in New York State, you would be right. In Indiana, the statute seems to be somewhat vague. There's another distinguishing factor there also, that when the homeowner woke up, instead of confronting him, the 5 burglars, young 16-year-olds, turned and ran, and one of them was shot and killed. So there are very few cases in Indiana where this type of case has been prosecuted under this theory, but in both of those cases, the burglars were in fact armed and confronted the homeowner. So this is a case where the facts are a world apart and world different from that. So I would think that there's a good possibility here that the statute would be overturned as being vague and unconstitutional.
You guys surprised me that it even got to the point where it's now at the Supreme Court level? You would think, I don't know, any judge that you've been in front of, I'm not trying to get you in trouble here, but when they see the facts of the case, they say, time out, guys. You know, this is, what is it called? An FMR, right? Mm-hmm. We're not talking, this isn't reached this threshold here. Try again. You know, you're overcharging the case. You surprised it got to this point?
No, because apparently in Indiana, as I'm reading, there have been other cases where the statute has been upheld. There was a case in which burglars went in, they tied people up. One of the people got loose, grabbed a gun, and shot one of the burglars, and that was upheld. It is, I think, an abuse of prosecutorial discretion to hold people responsible in circumstances like this. It is entirely understandable if there's a death that is foreseeable and it is committed by one of the people who are committing the underlying felony. I get it. You know, you should be held responsible for the foreseeable consequences of your actions. But in this case, none of these kids were responsible for the murder. None of these kids could foresee the murder. They have absolutely no accessorial liability with the person who actually does commit the shooting. And I think it should be struck down.
And they're punished in accordance with the punishment that is reserved for a person who kills. So even though the punishment for the burglary was about 12 years, they're given 55 years, between 45 and 55. Even though there's no requirement of intent to kill, they are still punished in accordance with a murder charge.
And it's not just Indiana, is it?
No, this is a national trend. In fact, I know a case where somebody exhausted the appeals process in Florida very quickly. This was a young guy who lent his car to some friends one drunken night. The friends go to rob someone. One of the guys ends up killing one of the people at the home. This guy who lent his car was sleeping a mile and a half away. He was put in jail for life without the possibility of parole, convicted of first-degree murder, exhausted all of his appeals, and the only way that he got leniency was from the governor of Florida recently.
So, you know, Rich, you got to look at the legislative intent. If this is what the legislator wanted to do, they said, if I don't care what happens, you guys walking to this house, you're causing mayhem, whoever dies, you're responsible. If they've contemplated these facts and they actually, when they made the law, this is maybe what they intended. It
I remember
probably
in a
isn't.
much different way, but stand your ground. I heard some of the same arguments in Florida where they said, you know what, we'd had enough of it, and even if it doesn't work all the time, this legislation at least will.
There needs to be a connection to enact a law that holds people responsible for 50 years. There needs to be an intent connection, and that's at least what our felony murder statute gives you.
I don't agree. I mean, I think Doug is right. I mean, if the legislative intent is to impose this sort of harsh punishment, that's the legislative's right that
But it doesn't
they
make
have.
it constitutional, though.
Yeah, I know. Well, in terms of constitutionality, I mean, I don't know whether a Supreme Court or any federal court is going to overturn a statute where there's clear evidence as to what the legislative intent was, unless you're arguing cruel and unusual punishment. Another issue is you talk about prosecutorial discretion. You know, prosecutors for the most part, are elected to office. Prosecutorial discretion goes out the window when they realize that whether they deal with a case harshly or not, that's going to affect their chances of
Did
re-election.
you know, just from a layperson, that if this didn't happen in Indiana, but this happened in Illinois, the kids might be looking at 2 to 5, let's say. Yeah. But because he's on the wrong side of a state border, not a national border, right? All of a sudden, 2 to 5 becomes 50. And that, I know how it works. I got the civics of it. I know, states make up their own laws to a certain degree in terms of punishment, et cetera. But to a lot of people, it's just crazy.
But in a few states, the FMR has been abolished. So it's not fair to not even have it exist in some states and have no consistency across the board.
All right. Up next, as much as I've tried to avoid it all week, Jets quarterback Geno Smith. He's out for a couple months after the numbskull got sucker punched or punched, however you want to say it, in the locker room over a $600 dispute. Here's the question. He hasn't said if he will or he won't. But does he have a criminal case if he wants to go after the player or at least sue the other player, let alone his team, the Jets? We'll get into that and more after this.